Hello, I'm at the airport waiting for my plane. Look at all my glasses. I look like just being Melanie from the We Do Not Care Club. And this is why her stuff is so awesome, because this is exactly what we do. Okay, I have a couple minutes, and I was reading through the Friedman response to the supplemental Rule 11 thing that was filed the other day. And it's pretty calm for Friedman. I'm not sure he wrote it, but he definitely signed it. And I think it's a good illustration of why that was a bad idea to file that supplemental document. So he makes a couple of arguments, most of which are procedural, and then he gets to the substantive. So he says procedurally, the way that Rule 11 works is that you get a safe harbor period. So before you file a Rule 11 motion, you have to give the other side notice that you're going to do it. You actually have to send it to them. And you have to give them 21 days to withdraw whatever the pleading is that you're trying to get Rule 11 motions on, so that you're not just asking for Rule 11 sanctions all the time. And he's like, they're bringing up new stuff. This is not what the original motion was based on. The original motion was based on the same grounds as the motion to dismiss, and they can't just keep adding new information, which I think is probably fair. Now, so that's like a due process argument. Sorry, you're seeing people walking through the airport in the background. I don't know how to stop that. Okay. He then makes this argument that this is not new information. These depositions were taken late September, early October. That's not a strong argument to me, because everybody knows, and the judge knows. Sorry, announcements, lady. That it takes several weeks for deposition transcripts to be produced. So they probably just got the transcripts. So I don't think that timing argument is really a strong one. But then he goes into the substance, and this is what teeing up this issue allowed him to do, right? By bringing this up in that supplemental motion, because somebody had a hissy fit, I fully believe. It allowed them to be like, oh, actually, let us tell you what we found. First of all, this whole argument about Abel and Sarowitz weren't able to articulate the basis for their claims, we disagree with that. But you may remember that we said the exact same thing about Blake Lively and her retaliation claims, and you defended it, right? Remember when it was can you point to a specific article or a specific, and she's like, I can't point to one. And her lawyer said that's privileged, which was correct, because they're it's not a client's job to figure out how to plead legal claims. So they kind of, threw their own words back at them. When your client testified, they didn't know the basis. She didn't know the basis for her claims. You said it was attorney-client privilege, and you defended it. And guess what? We agree with you now that it's our clients. This is just typical litigation stuff. Everyone's always turning things on each other. And then, and this is where I think strategically and from a PR standpoint, it probably, all right, we have to closely monitor our baggage. It gives them the opportunity to be actually, we found stuff in discovery, and they keep it to Reynolds, which is interesting, because that letter was the first thing we've seen from Reynolds in a long time, because he's long since been dismissed out of this case. And, I thought, and I think a lot of people were why is Ryan Reynolds inserting himself back in this thing? Well, they're okay, then let's talk about Ryan Reynolds and the claims against him. We've actually been through discovery, and we've discovered more information about the shit that he was doing. It may not rise to the level of legal liability for purposes of the claims that we brought. And again, they have to argue that out. But just because it was dismissed for failure to state a claim does not mean it's sanctionable. They're not the same thing. And it just allows them, now we can't see it because it's sealed for now, but it allows them to show us, the public, oh, actually, we found all kinds of dirt about what Ryan was doing. So, I don't know if the judge is going to accept it or not. He could say, because remember, it was a motion for leave to file, and then you put the thing in, that's how people typically do it. It's I have a motion for leave to file this thing that I've gone ahead and attached. So the judge could say, I grant the leave to file, I'll put it in the file and I'll think about it later. Or he could say, I reject this new filing. I'm going to make my decision on those Rule 11 motions if and when they come, based on what was briefed before. Or he could say, because you're raising a new issue, which I'm not sure if it is a new issue. I'd have to go back and look at the original Rule 11 motion. But he could say, to the extent that you're raising a new issue, you're raising a new grounds based on new evidence, Mr. Gottlieb, you have to go back and give the Wayfair parties a 21-day safe harbor period, which is kind of stupid because they're not going to withdraw a complaint that's already been dismissed. So they kind of can't do that, which I think is probably another reason, as I'm thinking through this, could have been another basis. I think he kind of gets to it. He talks about withdrawing, but like, how can I withdraw the offending document when Your Honor has already dismissed it? That's the whole purpose of the safe harbor motion. So in other words, it feels like an ambush. But I think it was a bad legal move, and I think it was a bad PR move. We'll see what the judge does. If he accepts it and is like, okay, I'll take all this into consideration, I don't think that necessarily tells us anything one way or the other. Also, while I'm sitting here, this is kind of my morning video. I don't have anything to put behind me, so we're gonna look at Frank. Okay, look how cute he is. I miss him so much already. As I was getting ready this morning, I was kind of thinking about, so the video I made last night about the MJOP arguments and how it's all sort of starting to come together for me about all of the options that Wayfair has given the judge to enter judgment in their favor without having to say a woman wasn't sexually harassed, a woman wasn't retaliated against. They have given him this menu of options with the failure to exhaust administrative remedies and the contract documents, and was she employed and was she not. And yes, they have arguments in the motion for summary judgment about this wasn't severe or pervasive and that kind of stuff. But I'm not saying that he wouldn't. He has done that stuff in the past. But I think it's smart, and Shapiro, who I guess clerked for him, knows how he thinks. It's smart to give him options of, say, like, you can have an out for this that has nothing to do with the treatment of women. You can have an out for this that is, this was an incredibly powerful actress who negotiated her own role in this movie and had a lot of power on the set. This just isn't that kind of claim, without the judge feeling like he's taking a hit in, swatting away women who make sexual harassment claims, which I think is really smart. The other thing I was thinking is, federal judges, all judges, but particularly judges in New York, because it's the financial center of the world, are oftentimes very reluctant to get into businesses and tell them what to do, right? There's something called the business judgment rule, which comes up in a lot of commercial litigation that's like, listen, if this was just part of your regular operational business judgment, we're not going to get in the way. The courts aren't going to get in the way because this is America and capitalism and free markets and all that kind of stuff. I think the other thing they have done well is they have given the judge this viewpoint of this is big business. Everybody here was sophisticated. Everybody here was represented by lawyers. Everybody knew what they were getting into, what their options were, and everybody made very informed and educated choices. And if you now step in and say, well, Wayfair didn't run its business right, that belies the fact that this was a very sophisticated transaction, no matter how you slice it. I'm not sure that'll win, and I'm not sure I totally agree with that. But I'm just saying, in terms of their audience, which at this point is the judge, I think that was really smart. The more I'm looking at it, the more I'm sort of seeing all the pieces come together. All right, I'm off to DC. I'll talk to you guys later. Say hi to Frank. I miss him.